The topic of our panel was rules and standards, and as with many of the panels at this year's Federalist Society Symposium, most of us spoke in particular about Justice Scalia and his connection to the topic. I think all of the panelists understood that sometimes the law has a rule-like feel and other times standards are an important part of the American system of jurisprudence. Justice Scalia had a couple of different views, and they're in slight tension. They fit together. He liked rules. He wrote a famous article, The Rule of Law is the Law of Rules, but he also paid attention to texts. And the way in which the text was actually written. Now, when the text is written as a rule, that's easy. He can be a textualist and he can be a rule person. And in a nutshell, rules are rules. Now, there's a little bit more of a tension when the text is written as a standard, because if he's a textualist, it's standards are standards, but he's a rule person, so sometimes he had a tendency to want to at least try to read the standard as if it were a rule. Above and beyond his contributions to specific areas of law, a huge part of the Scalia legacy will be his contribution to discourse about the nature of legal interpretation in general, judicial interpretation in particular. He wanted to have a philosophy of adjudication. Whether he was completely successful in that, different people will have to judge. It may be that no one is completely successful, but Justice Scalia aspired to something like that, and in that aspiration, he's actually unusual, if not unique.